We're live now.
Hi, everybody. This is Tanya Freedman. It is a beautiful Friday morning in Southern California. And if it's Friday, it must be Friday Facebook Live with Tanya and with the experts. So I want to welcome you all here today. I'm just checking into LaFora and I see we are live, so that's great. And I want to welcome you all today to a very special event. We will be speaking to 3 top immigration lawyers in the US, and the opportunity to do that is just phenomenal. So I just want to start off by thanking the LaFora team who've given us this opportunity. We just, so grateful. We've had so many wonderful comments from the first Facebook Live session we did at the end of last year. And we have, I just wanted to especially thank Louise and Jean and Dave and obviously Chris Musello, who is the moderator of LaFora and is actually part of the team as well. So thank you for giving us the opportunity. The purpose of today is to ask questions of the experts. Right now, immigration again is in the headlines. Our president would like to put up a wall. So there's a lot of immigration debate right now, and whatever side you're on, one fact remains constant, and that is that it's an ever-changing landscape, and it's really important to keep yourself informed. In fact, yesterday, somebody mentioned a good analogy to me, and I thought I would share that with you. They said not being informed about immigration and the changing landscape is like driving a car over a mountain pass without the lights on at night. So today we're going to put the lights on. I see people are already joining us. So Joy Lorenta, Milanis, Rachel Kedua, Robert J. Roxas. So thank you so much, everybody, for joining us. We have a lot of people joining us already. Please introduce yourselves. This is very much a discussion. And just a short introduction before we get to the questions. So my name is Tanya Freedman. I'm the Chief Operating Officer of Connetics. We are a recruitment company. We specialize in direct hire, and we have hospitals all over the US. We work with hospitals, nursing homes, rehab facilities, surgery centers, all 50 states. I would meet with CNOs and CEOs almost every day. I travel a lot. And because there is a nursing shortage, the American Nurse Association said there will be 1 million shortage of jobs, of RNs, by 2022, which is just around the corner. So many facilities are looking at this as a strategy to supplement their current recruitment of nurses. It's really very important, as I said, to turn the lights on and ask the questions. So over the last few days, I know a lot of you have posted questions. I'm going to do a brief introduction of the experts that we have, and then we will go straight to the questions. This discussion, really, I want to make sure everybody understands. This is not about Connetics. This is not about me. This is about you and helping you to make sure that you make informed and good decisions in terms of your immigration. So on the panel, we have attorney Carl Schusterman. Carl, if you want to say hi.
Hi.
Yes, Carl and I are on the same time zone. So I'm going to read off just very brief on his bio, but if you're interested to know more about each of the experts, please make sure to look at the post that was posted, I think it was yesterday, into LaFora, and you can find out all the details. But Carl has over 40 years of experience in practicing immigration law. He is a certified specialist in immigration and naturalization law by the California State Bar. For 10 years, he's been voted as one of the best lawyers in America, a super lawyer by his colleagues at the bar. He was featured in February 2018 issue of Super Lawyer magazine, and he's been named one of the top 15 corporate immigration lawyers in the US. So he is known as the who's who of corporate immigration lawyers. So that's Carl, one of the experts we can see. Chris Marcello, who, as I might add, is a moderator of LaFora. So thank you, Chris, for giving your time to the LaForans and to all the nurses out there who are looking to come to the US. He has been an immigration lawyer graduating from the University of Cincinnati College of Law in 1998, specializes in immigration for healthcare, information technology, staffing, relocation, engineering, and financial. He works with some of the largest healthcare companies in the country. And his written work has been featured in American Immigration Lawyers Association annual publication, the Cincinnati Bar Association report, Worldwide ERC Mobility. Chris is a speaker at many national and international conferences. The list goes on and on. So another one of our experts. Welcome, Chris.
Thank you very much, Tanya.
And then last but not least is Jacob. Jacob Sapachnik is the managing attorney of the law offices of Jacob J. Sapachnik and is an active member of the American Immigration Lawyers Association. He is invited to lecture on immigration topics at various conferences in the US. He has published various articles related to the field. He's the founder of Find Jobs USA, one of the first job sites focused on international workers seeking employment in the US. He has been quoted and featured by numerous newspapers, TV outlets, worldwide, CNN Money, ESPN, NBC News, ABC, Fox, ABBA Journal, KPPS, to name just a few. He's written articles for various publications in North America, a pioneer in social media, and he graduated from Manchester Metropolitan University School of Law. So this is the real deal, everybody. Welcome to our experts, and we're going to get started. So I see that we have some people already starting additional questions. Kenny, Gabriel, Robert J, Roxas, and keep the questions coming. But before we get started, I want everybody who's watching to post into the chat box, are you ready for the lights to come on? If so, post yes. I want to see yeses coming. Okay, so here goes. Here are the questions. So the first question that we have is from Lois, and these questions comes from LaFora. So these are questions that you have all posted, and I've tried to get as many as possible, and we'll try to cover as many as possible today. So Lois said, hi, good day. I have a pending application going to the UK, and I've recently passed the NCLEX. My question is, what is more advisable, to go to the UK and process going to the US from there, or should I just stay and wait for my American dream here in the Philippines? Thank you. So to the panel, who wants to answer that question? Lois.
Yeah, I can tell you.
This is coming.
Yeah, I had gone to university in the UK, and under their medical system, largely run by the government, one of the things is, like, a nurse would get paid far less in the UK than the US. So if compensation is an issue, you may want to go to the US rather than the UK. Also, the weather, it's a little cold in the UK. So if you're in a place in the US, you might find that it's more adaptable than, you know, if you're a Filipino. My wife's a Filipino, and she had lived in various cold places, even in the US. And when she got to LA, she said, this is the place for me. So a couple things to keep in mind.
Jacob or Chris, do you have any comments on that question?
I mean, I agree with what Carl said about the only reason I would think that you would go to the UK if you are pursuing an American immigrant visa is if you do have a longer retrogression, and maybe you want to spend a year or two in the UK while you're waiting out your American retrogression. If you were to do that strategy, the two things I would keep in mind are, one, pay close attention to that visa bulletin because it will move quite a bit. And then number two, once you decide on a place to have your green card interview, do not change it. So when the National Visa Center stage happens, which is at the end of the process, it's the last stage of the process, you'll be asked to select a U.S. embassy. If, for instance, you're living in the UK and you select the U.S. Embassy in London, you should expect to have that interview in London. Do not try and change it halfway through to Manila. It will needlessly delay the case. The case would have to get sent back from London to the United States, and then from the United States to Manila. You can still set your appointment in Manila even if you're living in London maybe for a year. But just remember then that you should not try and switch it from Manila to London. You should fly back to Manila for that appointment. But other than that, like Carl says, I just think the U.S. opportunities are probably much, much greater.
Yeah. And I think I would agree with you, Chris. I don't know, Jacob, if you have anything to add, but just from the experience that we've seen, I think those are really good points, Chris. Because it's something that people don't often think about is the visa bulletin, the timeline involved. Because we have some people who have looked at the UK kind of as a stepping stone. And if you're going to look at it as a stepping stone, that can work, depending on the contract length. But you've got to be cognizant or be aware of the visa bulletin and kind of try and figure out the timelines. Because when you sign a contract, that's a legal binding document. So you need to take that seriously. But we had one candidate that actually didn't take into account the consulate, and now we have a delay because we're now trying to figure out that that whole process.
Tanya, do you say that your clients prefer a year or two of experience in a Western European country like the UK, or would they prefer, or do they tend to prefer more consistent experience back in the Philippines?
So it depends on the client and it depends on their need. But typically, if somebody has experience in the UK, that is perceived as a plus. We have one very large system that actually doesn't prefer that. So it's kind of on more of a case-by-case basis. But I think generally speaking, it can be a good stepping stone if the timelines are going to work. But there are some practical things to take into place, like where you're going to have the consulate interview. I'm pleased you raised that. Jacob, we don't see you. Can you hear us? Because it looked like you were dropping off. I think we might have lost Jacob for a moment. So I think I'm going to carry on with some of the questions. We have a question from Spanish Winner. I love that name. Spanish Winner says, my daughter has aged out by U.S. consul during our visa interview last February 2018 because according to them, she's already 22. What other visas, aside from Spanish Winner, I love that name. Spanish Winner says, my daughter has aged out by U.S. consul during our visa. A problem. Can you hear me now?
I can hear you, Tanya.
Oh, it seemed to be repeating itself, the connection. So Spanish Winner said, what are other visas, aside from the EB3, she can apply to immigrate here in the US? Where or how to process any of these visas? I'm willing to play an immigration lawyer if needed.
Well, I think one thing that they should keep in mind is something called the Child Status Protection Act. So it's a law enacted by Congress back in 2002. And even though her daughter's age may be 22 now, when the priority date becomes current, when she reaches the beginning of the line for the green card, the amount of time that the petition, which we call a Form I-140, was, when it was filed by the employer and then when it got approved, the amount of time that it was pending can be subtracted from the daughter's age. So let's say she's 22. If the petition was pending for over a year and you subtract that from her age, her CISPA age could be under 21. So you definitely want to check that. And if If you don't understand it, you should, talk to a lawyer about that. I'll let Chris talk about some of the alternative visas that she might be eligible for.
Yeah, I'm with Carl. The first option is, as Carl says, to look at the CISPA, the Child Status Protection Act, because that may provide some opportunities. Unfortunately, if your daughter is over 21, she's going to have to qualify on her own merits, and so she essentially just gets any options that any other foreign national would get. She can look at a student visa, for instance. Perhaps she'd qualify for an H-1B if she has a bachelor's degree in a field like, let's say, physical therapy. The only other piece of this, something to think about, is after 5 years in U.S. immigration status, you will be eligible for U.S. citizenship, which will allow you to sponsor your adult children. Now, it's quite a long processing time, but that's at least another option for you. But the real answer, unfortunately, is there's not very much good answers unless you can qualify for that Child Status Protection Act. Okay.
Well, thank you for that. I think we seem to have lost Jacob. I just got a message from him that he seems to be frozen on his side, so he's trying to reconnect. So I think we'll just continue now until hopefully Jacob can join us. So just to go back to Spanish Winner for a second. So she said that it looks like she's already been to the consulate.
The real answer, unfortunately, is there's not very.
So would she be able to go back in and ask them to re-evaluate her case with the Child Protection Act?
Yeah.
Oh, she can.
Yeah, we've had a number of those cases. It just seems like the Child Status Protection Act confuses a lot of people, and we've had consular officers all over the world that have misapplied that. So we get another appointment back at the consulate, and we show them that under the Child Status Protection Act, after you do the formula, she is under 21 and should get a visa. So it's definitely something worth checking. I know when we had a case, it had gone all the way to the U.S. Supreme Court about the Child Status Protection Act.
Wow.
So they would have me do a lot of seminars to other lawyers, and I would make a joke because the attorneys would get so confused. They said, that's why I didn't go to medical school, because I wasn't an expert in math. I became a lawyer, and now I have to learn about this Child Status Protection Act. But you know what? It's not that complicated. It's just simple subtraction. You take the date again when you get to the beginning of the line, and you subtract not how long you've been waiting in all, but how long that I-140 petition was pending, and you subtract it from your child's age. If they're under 21, then they're in good shape. If they're over 21, then they have to look for other alternatives.
Okay. Well, that's good advice. So Spanish Winner, hopefully you'll win in your Child Protection Act case with your daughter, and you can keep us posted. I'm going to move to the next question. So this is from Janice Dematulak. I hope I've said that correctly. Good day. I'm not sure if it's appropriate to ask this question. So this, Janice, we want to make sure all your questions are answered. So I will go ahead and ask the experts. I just want to know my options. I'm currently working abroad and stable where I am. My priority date is current, and I'm just completing the requirements for facility interview. I already had an ID schedule. I'm not sure what she means by that, but my agency delayed it. Oh, I think it means a consulate schedule interview, but her agency delayed it because I don't have a facility yet. So I think Janice must be with a staffing company. My question is, if I decide not to push through with the visa process, what will be the implications? My agency is requiring a hefty amount of payment if you decide to discontinue the application during the visa issuance stage, of which I'm currently in. Do I need an immigration lawyer if I decide to discontinue? And I think basically, Janice goes on, but I think she's just unsure of what to do in that situation. Any ideas of how to help Janice with this situation? Chris or Carl? We seem to have lost Jacob, unfortunately.
Yeah. So, I mean, I think a few things to think about. So the first is, it sounds like you're about 98% of the way to receiving your U.S. green card. It's disappointing, I'm sure, that your employment sponsor has postponed your interview. My hope is that that is maybe just because of the holidays, perhaps, and early in 2019 here, they'll be able to find you a facility. So that's the first point. Second point is I think you need to think about what you want for the next phase of your life. Do you want to stay in your current situation, or do you want to come to America? If you want to come to America, then I would probably just continue through with your sponsor, and I'm sure things will work out. I've certainly seen a lot of situations where the immigrant visa interview is delayed, but ultimately it works fine. If you do want to stay in your current situation and you do want to cancel your immigrant visa, you do need to keep in mind that you have a contract signed with a company, which isn't an immigration issue that myself or Jacob or Carl are experts in, but it is something you'll need to consider. There is likely a lot of money that sponsor has put into your petition, whether it's immigration fees, perhaps they've paid for your testing, your visa screen, your English fluency, your TOEFL, that sort of thing. And so they are likely going to want to be to recoup the funds that they've put into a lengthy and expensive process. Again, that's not really my area of expertise. That's something you'll want to consult with an employment attorney, either here or in your home country. But I think the first step is to really ask yourself, not what do I want to do tomorrow, but where do I really want to be in 2020 and 2021 and 2022? And if the answer is the U.S., I'd probably continue through with the process.
Yeah, I think that's definitely good advice. The immigration landscape is constantly changing, but the one thing that I think is a constant, and that's really important, and I really want to stress that to everybody who's listening, is it's really important to always be professional and ethical in your practices. If you have signed a contract in good faith, it's up to you to read it, make sure you understand all the implications thereof. But it's a serious commitment, and it's a commitment on the company side as well as on your side. And I think, as Chris said, it's very important to take that seriously and to be ethical and professional in whichever way you decide to go. Jacob, Jacob, I think you're back. Do you want to give us your opinion of
sure.
Dennis?
I think two things I wanted to mention. First of all, about the UK. In 1 second, and I went to school over there, and I think that the one thing that attracts nurses over there is the fact that they do get some help from the government, whether it's to finalize education, but also to go into work in certain hospitals that are not so popular by local European state members. So that's one thing. But as far as this topic with the contract, I do see it as a long-term life-changing experience. So those nurses that come to the U.S. and they're able to stay here and get a green card, they change their own life, their family life. So it's a long-term consideration. I do agree that.
Yeah, Chris, Carl, I'm not sure if you want to add anything, but I think we basically covered the main points for Janice. So I wanted to ask another question. Ma Flor-de-Lisa asked, my brother sponsored me under a family petition many years ago, which is still pending. I went to Canada during the retrogression years, and I'm now a Canadian citizen. My agency got me a job in the US, and I leave for the States soon. I am excited. We're excited for you, Ma Flor-de-Lisa. It's been a long wait, I'm sure, so we're happy for you that you're coming to the US. But the question is, I'm not sure how my family petition will impact the TN. What do I say when I cross the border?
There is a memo. Yeah, there's a memo on the TNs that even if you have a petition pending, whether it's through an employer or through a family member, as long as you can convince the person, they call it the CBP, the Customs and Border Protection Agency, that on that specific trip, you will come to the U.S. temporarily to work and leave again. You won't just stay here and get a green card. they are supposed to let you into the U.S. So the bottom line is you should be eligible for a 3-year temporary TN visa, and you can just keep waiting. The wait for Filipinos under the brother-sister category is now about 24 years. So I'm not sure when your sibling applied for you, but you can still come in on the TN while you're waiting for that.
I agree. I haven't seen any issues at the border for whether they're Filipino nurses or any other that are pending family petitions. They seem to understand that it takes years and they have to let them in and work. But again, they have to show some intention to return.
Okay. All right. So Flordelisa, you got your answer, and hopefully your last leg of your journey to the US will be a smooth one. Okay. Idlikar Dulai asked, do the PD can be recaptured for employment purposes even if the petitioner has died already? The PD has become current before he passed away. So I think Idlikar is talking about a family petition here.
Yeah, you definitely want to get that to an attorney, but basically if the primary sponsor has not completed through the immigration process, there's not too many options. There can be one or two though, but that's such a specific question. It's probably something that they'll want to actually engage an attorney to look at specifically.
Okay, so the specific case. So Idlikar, you need to reach out to an attorney to help you. Okay, so moving on to the next question. We have a question from Mark P, who asked, I was a nursing student in the USA and I got a sponsor when I graduated. The petitioner did an adjustment of status green card and I got my EAD card. So great news, Mark. I'm sure you're really excited about that. How long before I will get my interview and my actual green card?
So the interviews are taking longer and longer because until October of 2017, people who were getting their green cards through jobs never had to go through interviews at all. It was just family members and other types of green card interviews. So now they've added all the employment-based people to the mix, and the waiting times, which in most cities were around 6 months, have now gone to over a year. If you go to uscis.gov and look at their resources, you can go city by city and see how long it takes to get an interview. One thing, though, that I caution you is they don't say, oh, it takes 12 months. They'll say something like, oh, it takes 11 months to 2 years to get an interview. So you don't know quite where you fit in. But if you have a lawyer in that particular city, they probably have so many cases that they'll be able to tell you with some accuracy about how long it would take to get your interview.
It's also taking longer to get EADs these days. What used to take 90 days is taking much longer right now, which is also a problem for them.
Yeah. And I think the one thing also is that we've seen a lot of, nurses. I mean, it's such a frustrating process and it's so stressful. I was an immigrant myself many years ago. I came to this country almost 20 years ago. And proud citizen today, but I understand personally how hard it is for many people. And I think that the way the timelines are just getting longer and longer, it just adds another level of frustration. But I think we just have to know that you've just got to be patient, right?
Exactly.
Okay, I'm going to take one or two questions that people have posted. So I have the questions people posted during the last week or so, and then I'm going to jump in and take a few questions from people who are watching us right now. So Kenny Herodius asked, if ever I was given a chance to travel at the US as a tourist, will it affect my existing NCLEX application? So I'm not sure if, Kenny, if you meant just your application to write the NCLEX, or if you meant from an immigration perspective.
Maybe he means the fact that he comes as a tourist will it affect his future immigration, which
not 100% sure. what he means. I think maybe if he's got an NCLEX application, if he comes on a tourist, does that affect anything? You know, when he comes into the border patrol?
No, it shouldn't have any effect at all, really.
Yeah. Okay. So Kenny, no need to worry about that. Lim I says, is there a way your agency can sponsor a visa for those nurses who are NCLEX passes but don't have enough hospital experience? Oh, okay. So that's one's for me. So Lim, yes, Lim. The answer is yes. We have multiple clients, so we do have some acute care hospitals that will not sponsor you if you don't have hospital experience. But we have nursing homes, long-term care, skilled nursing facilities that will consider you if you do not have hospital experience. The thing, though, that I would encourage everybody for, and this is really important, you know, I mean, we've all been doing this a long time. Is please make sure that while your case is pending, that you keep up your experience, because nursing in the US and nursing in any other country in the world is very different. And it's really important to keep your clinical skills up so that when you get here, you can make a smooth transition. Then another one, Lou Andrew Renola said, I've got my master's degree in nursing and on continuing 13 years of hospital experience. Is it true that EB2 application has a greater chance of denial in the US immigration? And if yes, why? Jacob, maybe if you want to take that question, because
yeah, I think that you know, I think that's kind of like a myth, not just in nursing. I mean, you know, EB2, people are trying to get into EB2 because they think it's faster. But if you don't qualify for this category for whatever reason, obviously the chances of denials are there, just like any other. And again, especially for nurses, it's not something that is so common. So I think that's the reason why it's kind of like nurses are trying to get H-1Bs. Not all of them can do it, but those that can will get it. But those that they'll try and are not qualified, they're not going to be able to do it.
Yeah, I think what they want to consider is, you know, there's a lot of nurses in the United States who have 2-year degrees. And that's why, you know, in the Philippines, almost all the nurses have 4-year degrees. And the H-1B job is a job that requires a 4-year degree. So if your employer in the U.S. is hiring U.S. nurses on 2-year degrees, they can't say, oh, well, we need a 4-year degree for this job for the Filipino, but not for the U.S. citizen. And it doesn't make a lot of sense. So the ones that we have been successful over the years in getting EB2s are nurses that always require an advanced degree. So a couple examples would be a nurse practitioner. Another example would be something called a CRNA. My daughter-in-law is a CRNA. That's a certified registered nurse anesthetist. So basically, they do what an anesthesiologist does, but they're a nurse. So you know, if you're in one of those specialties, you may be able to get an EB2. But if you're just doing, you know, regular nursing care, or you're an ICU nurse or something like that, you're going to have to go with the EB3.
Yeah. Yeah, and there's a lot of misinformation, I think, about H1s for nurses and EB2s for nurses. I think we did talk about that a little bit in the session we did in November. So if anyone has questions about that, you might want to look at the recorded version of this, these Facebook Live sessions that we did in November with the experts. Robert J. Roxas says, my cousin is a Filipino born in Saudi Arabia to both Filipino parents. He has passed NCLEX and is looking for a sponsor. Can he use the cross-chargeability of EB3 visa through Saudi Arabia? So he was born in Saudi.
Yeah, he should be. So just for those of you who are unfamiliar with cross-chargeability, it starts, but when you're thinking about cross-chargeability, think about the visa bulletins. So the visa bulletin comes from the fact that the U.S. government tries to make sure that 1 or 2 or 3 countries do not use all the employment-based visas and family-based visas for that matter. And so each country is capped at about 10,000 or so visas per year. The only countries that ever really reach that limit on the employment-based side are the Philippines, Chinese, Indians, and every once in a while, Mexican nationals. Other countries do not. And so it goes by country of birth, not country of nationality. And so if, even if you have become, for instance, a UK citizen, which has essentially no retrogression under the EB3, since you were born in the Philippines, you still come under that Filipino visa bulletin country of birth. In this question, the applicant sounds like he was born in Saudi Arabia. And so therefore, even though the individual is a Philippine citizen and not a Saudi citizen, because he was born in Saudi Arabia, he should be able to use that date to move under the Saudi EB3 visa bulletin, which is essentially current. Cross-chargeability is a slightly different concept. What that says is that if one's spouse is born in a different country, you are able to use that more favorable spouse's country, even if that spouse is not the principal immigrant. So very quick example, if you were the nurse and you were born in the Philippines, but you marry someone who was born in Malaysia, because Malaysia has no retrogression or very small retrogression in some months, even though your spouse is not the nurse, we are able, as the attorneys, to file for your case by virtue of the fact that your spouse is Malaysian, and therefore your case is going to move considerably quicker.
Okay. So the answer to your question, Robert J., is yes. Your cousin can come under the Saudi where he was born. So that's good news for you. Okay, I'm going to go back to the original questions that we have. We have so many questions coming in. So thank you, everybody, for sending all your questions. I can see the questions coming in fast and furious. So I really thank the panel as well for giving their time, because this really does help the lights go on. Okay, so we have a question from Maria Francis. My daughter, Maria Francis, her daughter has 2 employers. Both filed the I-140. What would be the legal implications? Yikes. How does that work, panel?
Well, it's possible to have 2 employers, but you know, it's like when you get married, you got to pick the best one. So you can't have 1 employer. So you're not going to get 2 green cards, one for the right hand and one for the left hand. You have to choose which one you want if you have 2 I-140s approved.
Okay.
So I guess it will depend on. What I've seen in the past is that, you know, some employers file an I-140 and then they are not doing well financially, so they're not going to be able to finish the case. So I think that those 2 applications can go parallel, but then you have to choose one, and maybe you'll go with the fastest case or the best employer.
Okay. So Maria Francis, your daughter has a big decision coming up. As Carl says, she can't be getting married to 2 people, right?
For richer or poorer.
Yeah, exactly. Kay Key says, hello, I'm here in the US and I'm planning to start the petition for my husband. I want to know how would it affect if he will apply for a tourist visa if he has a pending petition with me? What does he need to do first? Get a tourist visa before I start the petition process? Or it's okay to start petitioning him now and get a tourist visa while waiting for the petition grant? Thanks a lot. Okay, Kay, I'm going to hand your question to the panel. What's your expert opinion?
I think that if it's feasible to do it before, you know, a tourist visa is not that doesn't take that long. I would just have him apply for the tourist visa before the immigrant petition is filed. But even if it's filed, as long as he can explain and show ties to the home country, overcome 214B, then I think it should be okay.
Chris, Carl, do you agree with?
So what the, you know, I mean, I'll put on the hat of my former employer, the Immigration Service. I mean, when the husband's coming in, I mean, when he's applying for the tourist visa and when he's coming in on the airplane, they're going to be skeptical. They're going to say, well, you know, you're married to a permanent resident. We know you want to get a green card. So how can we trust that you're really going to go back to your country? So it's going to take a lot of convincing. Definitely have a non-refundable round-trip ticket. Definitely have a letter from your employer saying, you know, we've given this person 2 weeks vacation and he's got to be back at the job. But it's difficult. It's really difficult to do that. On the other hand, I know from years ago, my wife had applied for her sister from the Philippines, and then you're looking at a 24-year wait. So she was actually able pretty easily to get a tourist visa, come to the U.S., go back over and over again, because they didn't think she was going to stay 24 years. But even so, she would always have her kids and her husband back in the Philippines. She had a job, and that made it a lot easier. If you're married to a permanent resident, that's going to be a tougher sell at both to get the visa and to get in at the airport.
Yeah. Okay, thank you for that, Carl and Jacob. I'm just looking at the comments. So Hards Navarro says, shout out to Chris Macello. So she knows Chris. I think we have time for one more question. We decided that we were going to keep these sessions like to about 45 minutes. And the good news, the exciting thing is we're going to be doing one of these a month, every month. We're going to be doing a question and answer with the experts. And you know, as we said, we're very grateful for their time. So I'm going to give one more question. Oh, I wanted to also just mention, we had a question from Jamie Adaja, who said, when do we file taxes? How long should we be in the US before we file it? How do we go about filing? Jamie, I wanted to just mention to you that we're going to be doing some Facebook Live sessions with some financial people coming up on the forum, so look out for that, where we're going to be talking about taxes, about credit history, you know, all of the things that you need to know from a financial perspective of living in the US. Because I think for so many people watching, you know, all your thought patterns are how do I get there? How do I get there? And it's so frustrating and so distressing. But you don't always think about when you get here, the things that you need to take care of. So we're going to be sharing some information about that in the coming months. So look out for that. So for the last question, I'm going to ask from somebody posted today into the forum. And thank you for all the questions. There have been some great questions here. Raven Archel Lim asked, is it possible to process at the same time the CNA immigrant visa, and the NCLEX? If I pass the NCLEX and get the priority date for the CNA immigrant visa, do I need to work as a CNA for how long before I get to practice as a US RN? Panel, anyone want to take that question?
Tanya, you were breaking up on me there. I'm not sure I heard the whole question.
So the question that Raven posted today is it possible to process at the same time the CNA immigrant visa and the NCLEX? What if I pass the NCLEX, get the priority date for the CNA immigrant visa? Do I need to work as a CNA for how long before I get to practice as a US RN? Thank you.
I assume by CNA she means a certified nursing assistant, not a certified nurse anesthetist. So if it's a nursing assistant, you cannot. You can get an EB3 visa, or you can get an EB3 visa under an NCLEX passed regular RN. I think the important thing to keep in mind, and maybe this is the simplest answer, is whatever visa you're sponsored under, that's what you should come in and work. So whatever your I-140 says, when you go to your visa appointment in Manila, you're going to, among other things, bring an updated employment verification letter. And that's the job that you should plan on doing in the United States. And you shouldn't have any plan in place to leave that employer. You shouldn't have a plan in place to take even a promotion, or for that matter, a demotion at that job in the U.S. once you come here. Having said that, it doesn't need to be for the rest of your life, but you should expect to fulfill the terms of your contract And if you don't have a contract, we normally recommend that you stay in that position for at least 6 months.
Yeah, I'm not.
Well, for any visa that you are, like an H-1B, you should not be changing your title or position after the visa is issued. Only if you've done an amendment in the future or things like that.
Yeah, Rachel, Raven, sorry, I hope that answers your question. Carl, I don't know if you had anything to add on that.
Yeah, well,
this question.
Yeah, I mean, you know, attorneys sort of vary as to the time difference, but I found out that the minimum amount of time that you want to stay at that job before you switch would be 90 days. Otherwise, the immigration service would come back and say, well, you committed fraud or something. I understand what Chris is saying. 6 months is, you know, might be a little more on the conservative side, but might be a wise choice for you. But don't just come in and, you know, 2 weeks later switch to another job, because you're going to be in big trouble when they find that out later on.
Yeah. And I think that's good advice, is stick to the rules, and make sure that you're conservative. And if you have a question, ask the experts. So I think that brings us to the end of our 45 minutes. And is there any last thoughts, Jacob, Chris, or Carl, that you want to share with everybody watching?
I just think that it's important that people get educated and understand what they can and cannot do before getting the visa, while they're going through the interview process. And even as Carl said, when they arrive to the U.S. at the port of entry, every stage can have issues, and everybody should be ready to deal with it and be very informed. That's why we're doing it here for you guys.
And I think I've checked out you know, all of our websites. I think that if people go to the websites, they'll find a lot of material that might help them. We have something on ours called the Nurse Immigration Guide. And I always say, I've spent so much time on it for the last 25 years that when people ask me, I said, well, my wife doesn't call herself a web widow for nothing. Go online and you can find a lot of stuff, and especially on the three of, you know, Jacob, Chris's, and our website and Tanya's website, they can find a lot of useful material. I realize we're all immigration attorneys, so when we say I-140 or this or that, you know, it just sounds like to somebody else like, oh, my sister or my uncle or something. But, you know, to somebody who's a nurse, you know, I-140, what's that? So, but when they go on the website, it'll be really spelled out in more detail.
Yeah, I agree with everything that Jacob and Carl have said. The only thing that I would also just add is, you know, the U.S. immigration system in the last 2 years under President Trump has been very difficult to deal with. It's been very stressful, not just for the immigration attorneys, not just for the recruiting community that Tanya's a part of, not just for the U.S. employers, but certainly for the nursing community and the workers who are going to come over here. And just on behalf of America, we just want to make sure that the Filipinos know that your work is very much in demand here. We get so many positive feedbacks from clients and other healthcare professionals and the U.S. public about what a great job the Philippine nurse community has just done for the United States. And so I'm sure it's stressful, and I'm sure people are getting weird RFEs and weird denials and weird questions out of the embassies and consulates. And please don't get discouraged, and please make sure that you're with a good immigration attorney and you're with good recruiters like Tanya's group at Connetics, and it will work. It will work in spite of all the stress and anxiety that you may be feeling.
Yeah, I think those are great closing comments from everybody. Thank you for that. You know, just to go back to the analogy that I spoke about in the beginning, yes, Jacob is right. There is hope. Please don't get discouraged. Please don't get despondent. We understand that this is a very stressful, very frustrating process. But in the same way as when you are driving in a car at night across a mountain terrain, you want to make sure that the lights are on, and that's our hope, is that we can get a little bit of light in terms of the information that we share. So please make sure to share this with your colleagues, share this with your friends. This Facebook Live will be posted into Lafora. Again, shout out to the Lafora team for making this available to everybody. We welcome your questions. Keep them coming. The panel have been amazing and have agreed to do once a month Facebook Live session. So we'll be posting the next date in February for the next session. And we look forward to a great year for everybody and hope to see you all in the US soon. Thank you, everybody.
Bye-bye.
Thank you so much.
Bye-bye.